Now back to one of our lead stories this hour. A Judicial Tribunal has cleared Eastern Cape Judge President Selby Mbenenge of gross misconduct in the sexual harassment case brought against him by former Secretary Andiswa Mengo. For a discussion on this, I am now joined by Alison Tilley from Judges Matter. Alison, a very good evening to you. Thank you so much for your time. If you could just give us your reaction when you heard these news.
Well, I think it's something that really divides down into a number of important issues, and I think one of them is the finding that in this instance the tribunal did not feel it was appropriate to consider the differential in status and power of the complainant and JP Mbenenge. So I think that was notable in the finding, and I think we also what was notable was the findings made in terms of her credibility, and I think that's obviously very important in reaching a conclusion, and that the tribunal found that she did not tell the truth about a number of the instances, the evidence that was laid.
So what do you think this means when it comes to the future of voicing such kinds of allegations or grievances in the judicial system against senior officials and judges?
Well, I would say there are certainly the conclusion can be drawn. I think that complainants will think twice and thrice about laying complaints, because obviously the complainant went through a very difficult process, and it did at times almost feel as though she was on trial. So I think that that is true. I think what is also true is that subsequently the Chief Justice has introduced a sexual harassment policy, and I wonder if that might not give prospective complainants some comfort in coming forward, in knowing that that policy is now in place. But I think certainly the message that many complainants will take away from this is that it's a difficult case to prove, and if you have been in a position where you have said anything other than a repeated firm no at all, at all times, there may be some difficulty in making the case.
When you're talking about the case being difficult to prove as well, watching what seemed like also her being on the witness stand, but also being heavily questioned about these WhatsApp messages, it brought into the fore things as simple as emojis, for instance, and what time you respond to messages and things like that.
Well, I think that's one of the difficulties in these matters, because there's who meant what, and I think the new sexual harassment policy really tries to deal with that by saying that these workplace relationships are in the justice system involving judges, magistrates. It's simply not appropriate in the workplace, and I think that might clarify things. Obviously, it's early days in terms of the sexual harassment policy itself. It's only been recently introduced, so we will have to see what difference that makes.
Yeah, and I think that sexual harassment policy was introduced in August last year already. But as we know, when it comes to policy and feeling it on the ground, sometimes that does take a while. So do you have confidence that perhaps in the next short while, or in a couple of months, or even will it take years, when you're looking at a time span of a policy being implemented, how long does it usually take to actually be effected on the ground?
Well, I think it depends on how earnestly it's taken up. And I have to say the initial indications are very good. I think the profession is really looking at it with interest. Certainly in the discussions we've had with whether it's lawyers or regulatory bodies or associations of lawyers, they are very interested in it. We'll actually be having a meeting with the Chief Justice and some parts of the profession in order to talk through the sexual harassment policy and its implications, and that will be in February. So I'm hoping that, we can do some work on the ground and just figure out some of the problems that exist. Who do you report to? Can you be supported in your reporting? And then obviously what are the consequences and how are those dealt with?
Just, Alison, I want to talk to you also about the JSC interviews, and in respect to Judge Ledwaba being the only candidate who had issues surrounding him and his integrity, but then also still refusing to kind of recuse himself as well. What picture is this painting of our judiciary when we're looking at, of course, these kinds of allegations and of course, these JSC interviews?
Well, I think his position is a difficult one in the sense that while allegations have been made, he hasn't actually had an opportunity to refute them. And I think we had imagined that, given the seriousness of them, that the Mbenenge Commission of Inquiry would give him an opportunity to deal with the allegations that were made, and that would have happened already. That obviously hasn't happened, and there are some other issues which have been raised. It's going to be difficult for him in the interview. I'm not sure that a JSC interview is really the appropriate platform to try and resolve a complaint like that. You're really being interviewed about the position, and in this case of Judge President, it's not intended to try and sort out the facts relating to a complaint. So I think it's going to be complicated, and I certainly hope that there is some measure of resolution that's reached between now and then.
Before I let you go, Alison, just going back to the news that came out today about Eastern Cape Judge President Selby and the ruling that was made there. We speak about, the change in legislation that could put us on the right track. Just in layman's terms, in future, once that policy is properly enacted, with this exact same case that Andiswa Mengo brought forward, would we see a different outcome?
Well, I think the thing with the policy, and let me just highlight two aspects. I think the first is that perhaps she would have had more support earlier on. And I think we know that one of the issues that came up was, who exactly drafted the affidavit in which she laid the complaint. And there were just what seemed to be procedural difficulties, and she was found wanting in relation to those. So perhaps that might not have arisen. But I think the second and maybe the more important point is that you simply are going to be in a position where this type of relationship, consensual or not, is going to be inappropriate in terms of the policy, and I think that will also create a different framing when issues like this arise, which I have to say they probably will.
Because he was found guilty to a certain degree, but not on all counts. Because, I mean, we also heard from his team saying that he will be back to work as soon as possible. And if we're looking at the key principles of the policy, when it comes to zero tolerance of sexual harassment, it's clear and confidential and fair procedures. It speaks about accountability. It speaks about a safe and respectful workplace that is free of discrimination or intimidation. Does it mean that if you are in that workspace and you do respond to a message that could be perceived as flirtatious, that means then already your case is null and void, or it's struck off?
No, I don't think that would be the case. I think you would still have to prove misconduct, whether ordinary misconduct or gross misconduct, and we don't know exactly what a breach of the policy would mean in terms of that. What I think we do know is that as far as Judge President Mbenenge is concerned, is that the tribunal's finding still has to go to what is known as the small JSC. So this isn't actually the end of the road in terms of the tribunal, and they will be making a finding, and then that may be taken on appeal. So I note that the Judge President says he intends to go back to work on Monday. There is nothing stopping him from doing that. He was not suspended. He was placed on leave. And if he chooses to go back, my understanding would be that there's nothing stopping him doing that.
Yeah, but as you mentioned, it's certainly not the end of the road yet. And just finally, when it comes to that zero tolerance for sexual harassment as part of the key policies in this new legislation as well, it sounds like a blanket statement, but that would really safeguard potential victims, right? Even if they did seem to consent.
I think it would, and I think the difficulty of consent is precisely one that this tribunal wrestled with, and I think they really came to the conclusion that the disparity of power between the Judge President and the complainant was not relevant. And of course, I think they also cited Constitutional Court decisions, which of course indicated that it is important they distinguished this case from the Constitutional Court decision. So I think we are in a position where having a flat ban on that kind of relationship may assist. I don't think it's going to be completely decisive. In other words, if it can't be that if there is any kind of relationship, that would then immediately rise to the level of gross misconduct. So I don't think that will be the case.
Alison, thank you so much for your time. We shall wait and see. As you said, it's not the end of the road yet.